I move that the subpoena be issued to Attorney Michael Wesley Poa in his capacity as the former Chief of Staff of Vice President and DepEd Secretary.
The committee will now act on the motion. Is that an objection to the motion of the Honorable Tino?
I object. Madam Chair, I could not find nexus borne by evidence or ultimate facts that would now make the Chief of Staff and lawyer of the Vice President to be subpoenaed. In fact, he has entered this appearance as counsel. So I object, and I would like to know about that. Are there documents that would show that he has been part of these confidential funds? Are there any? Because if there's none, there is no reason to call him and subpoena a lawyer.
Those who are in favor of the motion for issuance of subpoena ad testificandum to Attorney Michael Poa, please raise your right hand. With 34 votes in the affirmative, the motion is granted. The committee is directed to issue the necessary subpoena to Attorney Michael Poa. So ruled.
So therefore, the respondent here, as always, have the right counsel. That the presence of counsel of the respondent has the right to cross-examine directly the witnesses or the complainants. And secondly, there is no need for the Vice President to appear in hearing because that is her right not to be able to appear, and we can make conclusions out of her non-appearance. So, Mr. Chairman, I am saying that we just have to give the right, otherwise there will be no due process if only the members can ask.
Kaso hindi naman po ganun eh. Sa buong Pilipinas, wala po kayo, never po nangyari sa preliminary investigation. Nagkaroon ng cross-examination or nagkaroon ng opportunity na mag-cross-examine ang counsel at ang complainant. Thank you, Madam Chair.
Eto na mga boss, kakapasok lang na balita. Grabe si VP Sara, nagulat, Tumis-Tigo na si Poa. Inutusan ng prosecutor, binasahan na ng impeachment. Base sa impormasyong kumakalat ngayon sa social media, tetestigo na si ni Michael Poa, ang nag-iisang tatayong abogado sa impeachment ni Vice President VP Sara matapos siyang ipasepina ni Congresswoman Jinky Luistro. Kasabwat din daw siya ni VP Sara sa pera ng DepEd. Sabwatan sila ni Duterte sa confidential fund, pero pinagtanggol ni Congressman Rufus Rodriguez si Michael Poa. Bawal daw to sa impeachment ni VP Sara. Hindi daw nila pwedeng ipatawag para ipakulong ang abogado. Bigla siyang kumakampi kay VP Sara. Kaya ito, sabay-sabay nating panoorin kung paano si Vice President Sara Duterte, grabe nagulat, Tumis-Tigo na si Attorney Michael Poa. Inutusan ng prosecutor, binasahan na ng impeachment. Pero bago tayo magpatuloy, baka pwedeng i-click nyo muna ang like, share, comment, subscribe at i-hit nyo na rin ang notification bell kung gusto nyo ng mga ganitong klase ng video para laging updated kayo sa mga susunod pa nating ibabalita. Kaya tara, panoorin na natin to.
Madam Chair, may I make an additional motion for the issuance of a subpoena?
Like to make another motion for the
Yes.
issuance of subpoena.
I move that the subpoena be issued to Attorney Michael Wesley Poa in his capacity as the former Chief of Staff of the Vice President and DepEd Secretary from 2022 to 2023. In such capacity, he has very material and relevant information on how the confidential funds in the DepEd were used, and in particular, he had a direct role in the preparation of the accomplishment reports relating to the use of the DepEd's confidential funds, some of which these accomplishment reports have been the subject of the request for subpoena that this committee has approved.
May
So
we
I
hear
so
from
move, Madam
our
Chair.
endorser? Would you like to comment to the motion of the Honorable Tino? He wishes for the issuance of subpoena ad testificandum to Attorney Michael Poa, considering that during that time, he was assuming the position of
Chief of Staff of the DepEd Secretary.
COS
Yes.
of DepEd.
Undersecretary, with the rank of Undersecretary.
Honorable De Lima?
My motion was pertained only to the custodian of those COA audit records, including liquidation reports, disbursement vouchers, certifications, and related submissions from the custodian, the official custodian of the Intelligence and Confidential Funds Audit Office of the Commission on Audit. I won't have any strong objection to that request since it's related to this item.
All right,
The
so
subject matter of the first motion that I put forth, which was approved by the body.
the
Thank you.
chair will now act on the motion. The
Madam
committee
Chair.
will now act on the motion. Is that an objection to the motion of the
Definitely.
Honorable Tino?
I object. Are there documents that the Chief of Staff, Attorney Poa, has signed that he would be a witness to identify? May I ask the proponent?
Before we entertain the objection of the Honorable Rodriguez, let me just formalize that there is a motion raised by the Honorable Tino to issue a subpoena ad testificandum to Attorney Michael Poa, considering that he was the Chief of Staff of the Office of the Department of Education during the alleged period of 2022 and 2023. Do I hear a second?
Second.
The same has been seconded by the Honorable D.S. Konghon. Now let's hear the objection of the Honorable Rodriguez.
Madam Chair, could not find nexus borne by evidence or ultimate facts that would now make the Chief of Staff and lawyer of the Vice President to be subpoenaed. In fact, he has entered this appearance as counsel. So I would like to know whether there are documents which he certified or he signed that would make him be able to be invited to be given subpoena to appear in this committee. Otherwise, then we can, just because they are in the office of the Vice President, we'll be giving subpoena to everybody there in the Vice President's office. So I object, and I would like to know about that. Are there documents that would show that he has been part of these confidential funds?
Yes, Madam Chair. In the third complaint endorsed by the Honorable De Lima, there is a section extensively discussing the role that then USEC POA played in preparing the accomplishment reports pertaining to the use of the confidential funds, where and the complaint cites the transcripts of the hearings of the Committee on Good Governance on this matter, where USEC POA admits that he was ordered by the Vice President to submit these accomplishment reports, and also cited in the complaint that the several Army units denied what was claimed in these accomplishment reports.
So we've heard the justification of the Honorable Tino. We've heard as well the justification and the objection of the Honorable Rodriguez. We are a collegial body, so we shall now proceed to vote on the motion
Before
of the
the
Honorable
voting,
Tino.
Madam Chair, I would like the proponent to show to us documents, certifications that had led to the release of these confidential funds. Because we are now already on the hearing, precisely. Are there any? Because if there's none, there is no reason to call him and subpoena a lawyer.
Madam
The
Chair,
Honorable
as I
Tino.
said, I cite the complaint itself, the third complaint. Specifically, starting from
The process of utilization of the alleged confidential funds is not confined to the documents. There could be actions that contributed to the utilization of confidential fund, which might be covered by the testimony of the possible witnesses.
okay. Well, starting from paragraph 269 of the third complaint, page 90, there is a reference to former DepEd spokesperson. He was spokesperson as well as chief of staff, Michael Poa, testifying that he received envelopes directly from Vice President Sara herself. So this has to do with the allegation on bribery. And further, And there are other sections as well pertaining to the use of the confidential funds, Madam Chair. If the if Congressman Rodriguez would want, we can provide given enough time, Madam Chair.
Madam Chair, we are now voting, so we should be able to get it. There is. The fact that he's chief of staff and counsel will not, implicate him to be able to have that if there is no document. So I would object to that, Madam Chair.
With the indulgence of these two gentlemen, as to whether or not there's relevance in the presentation of Attorney Michael Coa, will be a question that rests on the judgment of the justice members. We shall now proceed to vote. Those who are in favor of the motion for issuance of subpoena ad testificandum to Attorney Michael Poa, please raise your right hand. That concludes the voting. We shall announce the result. With 34 votes in the affirmative, 3 votes in the negative, and 0 abstention. The motion is granted. The committee is directed to issue the necessary subpoena ad testificandum to Attorney Michael Poa. So ruled.
Madam Chair,
Is there any objection?
discussion. Madam
The Honorable Rodriguez.
Madam Chair, the right to counsel is assured by the Constitution. So therefore, the respondent here has always have the right to counsel. In fact, in many cases, our rules of court is suppletory to the rules of impeachment in the House. And so therefore, this representation believes that first, they are entitled, counsels for both sides are entitled to send questions, and I agree with that, Madam Chair. But what I would like to emphasize is that the Vice President can always designate their counsel to appear in all the proceedings, so that we should be able to state there that the right to counsel, the right to be heard by herself or counsel is assured by the Constitution. But we know the response of the proponent of the motion as to that particular observation.
If I may confirm, the Honorable Rodriguez, you would like the committee to acknowledge the right of the counsel even in the absence of the respondent.
That's correct. Based on jurisprudence, Madam Chair, that although this is not a criminal proceeding, it is akin to a criminal case because we are trying to remove and there is also perpetual disqualification. And so, in other words, the Vice President can send her counsels here to appear for her. In fact, the right to self-incrimination is there. And a person who is now being investigated has the right to already not take the stand or at the time she wants to appear to be able to invoke it when she is asked an incriminatory question. So that is the position of this counsel. Thank you, Madam Chair.
Of course, based on the ground rules that was read by the Honorable Zamora, the right to counsel is described as assistance to clients or to the parties. Now it is being proposed by the Honorable Rodriguez that the same be acknowledged even in the absence of the respondent or the parties. May I hear the comment of the members of the Justice Committee? The Honorable Rodriguez.
Madam Chair, the right against self-incrimination is very clear. Under our rules, the criminal procedure rules, which are suppletory, because our rules are very, very, very pithy in terms of the procedure. 2 points, Madam Chair. The respondent has the right not to appear, and therefore she does not need to be present, because that is the right of a respondent, akin to a accused in a criminal case, as decided in the cases, Madam Chair. That's number one. Number two, the counsels here are not only to advise on the legal rights, they have the right to cross-examine, because the Vice President will not be present. If she's present, she cannot cross-examine witnesses, because she has lawyers. So therefore, 2 points. The rule that requires that lawyers can only, the participation is only to advise the legal rights of the witness is on the rules on the investigation in aid of legislation. That is expressly found in the rules in aid of legislation, the hearings. But it is not found in our rules. I've been reading our rules of procedure. There's nothing here that limits it to only advising. Therefore, in an adversary proceeding like this, we have to therefore hear the counsels if they wish to be present, but if not, then that is also the lookout of the respondent. But I believe that we should be clear in our rules that the presence of counsel of the respondent has the right to cross-examine directly the witnesses for the complainants. And secondly, there is no need for the Vice President to appear in hearing because that is her right not to be able to appear, and we can make conclusions out of her non-appearance. No need for her to appear. Thank you, Madam Chair.
Madam Chair.
Madam,
The Honorable Chua, are you raising your hand? Part of the proposed rule is giving opportunity to the complainant and the respondent and their counsels to submit questions to the chairperson so that they may be raised in the deliberation if no justice members are raising similar questions. Let us all be guided as well that the hearing proper in the Justice Committee is akin to a preliminary investigation. So, let us be guided by the fact that as well, that we're trying to establish here is merely probable cause, which means a justification to be able to proceed to trial, which will definitely happen not here, but in the Senate.
Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me read what is provided under our rules, the rules of procedure in impeachment proceeding. Under Section 7, it provides that if the committee finds that there is sufficient ground for impeachment exists, the committee shall conduct a hearing, which we are now doing. The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. Therefore, Madam Chair, it is very clear under our rules that it is only the members of the committee who can participate with respect to the examination and cross-examination of the members. Why? Because, like what you said a while ago, this is akin to the preliminary investigation wherein it is the investigating officer or the investigating city prosecutor who is asking clarificatory questions. We are not yet in the trial where the lawyers or counsel of the defendant can cross-examine the witnesses. Now, this can also be, we can also be guided by our rules of procedure governing inquiries in aid of legislation, which the Honorable Rufus Rodriguez mentioned a while ago, that under Section 13, appearance of counsel, here, the participation of counsel for witness during the hearing and while the witness is testifying shall be limited to advising on the legal rights of said witness. Why? Because this is a committee function. So, ganun din po dito. Ito pong ginagawa natin is also a committee function. The cross-examination, ang purpose po ng cross-examination dito is just to ask or just to clarify questions. Hindi pa po ito yung talagang trial proper wherein we can cross-examine thoroughly the witnesses. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable De Lima.
thank you, Madam Chair. I concur with the views expressed by the Honorable Joel Chua. as expressed very clearly by the Honorable Chair earlier, the proceedings today, the proceedings from now on, henceforth, would be the determination of probable cause. And therefore, this proceedings is indeed akin to a preliminary investigation. There are no formal direct examination or cross-examination in the proceedings before the prosecutor's office. Yes, we can recognize the respondents and the complainants' right to counsel, but their role ought to be limited because this is only preliminary investigation. Role like identifying affidavits can assist their clients, can assist the complainants, or can assist the respondent. But if they have questions, as expressed and as already laid down in the ground rules read by the Honorable Representative Zamora, they can course it through the chair. In that case, they are afforded the right to confront, the right to ask clarificatory questions. This is not a full-blown trial yet that happens in the Senate. Just to repeat, this is akin to preliminary investigation, determination of probable cause. The proceedings or the hearings before the prosecutor's office, and this is the prosecutors, the Committee on Justice, is actually also limited. And no full-blown examination, whether it's direct examination or cross-examination, being conducted or held at that point. So I think it's very clear, as expressed by the Honorable Chair and also indicated in the ground rules. We are not denying the parties their right to counsel. They have the right to counsel. They can assist for purposes especially also of asking clarificatory questions, but we have our own rules here, coursed through the Honorable Chair. Thank you.
Madam Chair.
The Honorable Ridon and then the Honorable Rodriguez.
Well, maganda po yung talakayan kanina patungkol doon sa konsepto ng karapatan sa pagkakaroon po ng abogado. But I think just for the record, meron pong sulat yung mga abogado ni Vice President Sara Duterte na wala naman po ata talaga din silang interest at this point na dumalo either ang pangalawang Pangulo o yung mga abogado po mismo. And I will read it for the record.
Madam Chair, we are still on our ground rules discussion. So that can probably wait and we will be able to discuss that.
No, just
because
to-
we are now on approving the ground rules. We are not yet determining what the council or the vice president is proposing or manifesting to us.
For
So
the
can-
guidance of the justice members, there is a pending motion for the approval of the ground rules read by the Honorable Zamora. Perhaps we will be proceeding to the letter sent by the lawyers of the respondent after we address the motion for the approval of the ground rules.
Yes, Madam Chair, but just to make the point that even if we talk about a conceptual matter relating to the right to counsel, if the counsels themselves are actually questioning these proceedings and the Vice President herself is questioning this proceeding, I think that needs to be placed on record, Madam Chair. So I will read it. For two Narvasas and Salazar.
Madam Chair.
The Honorable
Committee.
Ridon
That will
is
be out of order.
requested to defer the discussion on the letter of Fortune Narvasa until we address the pending motion before the committee. So if we can go back to the motion, the
Madam
same
Chair.
has been seconded already.
Other discussion because there were interjections.
That is with regards to
To
the
rules.
ground rules.
Yes, Madam
The Honorable Rodriguez.
Madam Chair, there is here a statement that in our rules, only members can ask questions. And I would refer now to Section 7. Committee finds, and then the committee shall conduct a hearing and examination and cross-examination by members of the committee. Very clear. However, Section 7 shall obey the Constitution of the Republic of the Philippines. The Bill of Rights, Madam Chair, Article 3, provides that the right to be heard by himself or herself or to counsel is inviolable. It is in paragraph, in section in the rules, in the Bill of Rights, is in the section on Section 2, and then also on custodial Section 2 and Section 4. So, Mr. Chairman, I am saying that we just have to give the right, otherwise there will be no due process. If only the members can ask, we should allow. Can I finish first,
They
Madam
have
Chair?
the right.
I have allowed my good chair to finish. So let me finish my manifestation. So therefore, Madam Chair, it is very clear that counsels should be allowed to cross-examine. Now, the issue here is that the rules provide that they submit the questions to the chairman. Will the chairman have the discretion to read or not? Or everything that will be given to the chairman will be read?
To answer the question of the Honorable Rodriguez, so long as the question is germane to the discussion pending before the committee, the chair will read the questions which are being submitted or which will be submitted by the counsels of the parties. That includes the counsel of the respondent.
Thank you, Madam Chair. But
Madam
just to
Chair.
be able to state that this representation believes to be able to afford really procedural due process, as pronounced in the leading case of Angtibay versus CIR, the 7 cardinal rights of a person who is accused, in this case, akin. We are really, this is even more than a criminal case because we are trying to remove the official who had the highest votes in the history of this country as Vice President. So what I'm saying, Madam Chair, we should allow the counsels to appear if they so wish and be able to cross-examine the witnesses of the complainants. That is the way to be able to afford the opportunity of procedural due process as is enshrined in Article 1 of Article 3 of Section 1 of the Constitution.
Madam
Let
Chair.
us be guided by the fact that this is not yet the trial.
Madam Chair, may
So
I be
what
allowed?
will happen before the Justice Committee is indeed merely a clarificatory hearing. Trial is different because, as has been repeatedly stated, only the Senate can conduct the trial.
Madam
What
Chair.
will happen before us is merely clarificatory hearing, and those questions are to be raised by the justice members. Of course, the lawyers of the respondent are free to attend the hearings. But with respect to their participation, I think that has been addressed in the proposed ground rules, that their questions may be submitted to the justice chairperson, who will be reading those questions to be answered by the resource persons.
Madam
Let
Chair.
us draw the line between the clarificatory hearing between the Justice Committee and the trial, which will happen in the event that there is probable cause in the Senate only.
Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. To answer the manifestation of my professor, the Honorable Rufus Rodriguez, there is no violation of due process, Madam Chair. Why? Because the respondent was given the opportunity to answer. That was the time when she is allowed to give all her answer. Now, sinasabi po natin that this is akin to preliminary investigation. Sa preliminary investigation po ba, did we allow the complainant and the counsel to cross-examine? No. It was only the investigating prosecutor who is allowed to propound question to clarify. Hindi pa po ito yung full-blown trial. And us, as member of the Justice Committee, that is our job to ask clarificatory questions. Yun po yung intention nito. To do otherwise, kung iba po yung nasa isip nito, dapat clearly and expressly nilagay po dito sa ating rules na yung examination and cross-examination can be conducted by members of the committee and or counsel and the complainant. Kaso hindi naman po ganun eh. Sa buong Pilipinas, wala po kayo, never po nangyari sa preliminary investigation, nagkaroon ng cross-examination or nagkaroon ng opportunity na mag-cross-examine ang counsel at ang complainant. Thank you, Madam Chair.
Ngayon, kayo bilang Pilipino, ano ang masasabi nyo at reaksyon sa balitang ito? Mag-iwan kayo ng komento sa ibaba at atin niyang babasahin isa-isa.